Welcome to this morning's session of the Kansas Court of Appeals. My name is Catherine Gardner, and I will serve as presiding judge today. And sitting with me, I'm happy to be with Judge Tom Malone and Judge Angie Coble. We'll be the panel. We thank you, counsel, for your flexibility in meeting remotely today instead of our original plan to be in person in Wichita. We appreciate that. Your case is set for 15 minutes, and I will go ahead and call the case of 127415 Alondra Morales Yanes, appellant versus State Farm Mutual Automobile Insurance Company, appellee. So appearances, please.
Singer on behalf of appellant.
Thank you.
And Michael Norton on behalf of appellee.
Very good. Appellant, you may begin and let me know if you're requesting any rebuttal time.
Yes, Judge. We'd like to request 5 minutes for rebuttal time.
That's granted. You may begin.
May it please the court. This appeal is quite simple whenever you boil it down. In this case, the Colorado law controls how judgment is entered. The Colorado statute at issue is 13-21-111.6. As part of that, there is the contract exception that outlines the statutory reductions that are required to be made, which none apply to this case. And then after those reductions are made, the statute says, quote, "The court shall enter judgment on such reduced amount." And so judgment in this case is the $24,295.26. And the second step of this analysis is we have to then compare it to the tender that was made before the lawsuit was filed.
Now, before you get into that, let me ask you about, you're saying the 24,000 amount was the judgment amount. That was the amount of the jury verdict, correct?
Yes, Judge.
But did the judge ever enter judgment on that amount?
The judge did not enter judgment on that amount, and that is where I believe, in part, the district court erred. In this case, the Colorado law, part of it, before I get into it, the Colorado law, one, it was stipulated to. And there was a stipulation where it says the parties entered into that says the Colorado law controls the damages and the tort-related issues in the case. And then after that was whenever the motions in limine were filed. The motions in limine in this case were in part dealing with this Colorado statute that's at issue. The only response that defendant or appellee had in response to that was they said that they agree with all of it. And so the stipulation in the controlling law from that moment forward was that this statute applies to this case. Taking it a step forward, further, the choice of law analysis also lends to the conclusion that the Colorado law would apply as well. The collateral source is a substantive law, and this is Colorado's collateral source rule. And under the guides of the Lex Loci Delecti, I may not have pronounced that 100% correct, but under those guides, the law of the state where the harm occurs is the controlling law, which is Colorado in this case. And so any way that you look at it, the choice of law analysis says that this law applies, but more so than that, specific to this case, there is no, the stipulation is what the stipulation is that this law applies.
But didn't the parties stipulate to the application of the State Farm policy? I mean, where do you apply State Farm's policy to this recovery?
The only stipulation that the parties entered into for the State Farm policy was to say that the Kansas law is the choice of law for the interpretation of the policy. The policy is at direct odds with this stipulated to and agreed to Colorado law. The timing of those two agreements by by State Farm kind of lend to showing what their intent was. The stipulation that was formally filed was about a week before these motions in limine were discussed. And so the agreement to the motions in limine saying that this Colorado statute at issue applies, then is the controlling agreement from that moment forward. In its application, the judge should have looked at the law and followed it to a T. The Colorado courts have already decided that the Colorado legislature spoke with, quote, exactitude whenever they wrote this statute. There is no ambiguity in the statute at all. Under Colorado law, there is no offset for things that the appellant has entered into a contract for. Those two in this case being the personal injury protection benefits and the health insurance payments made on behalf of the beneficiary to their medical bills. That was clearly laid out piece by piece in black and white in plaintiff's motions in limine. State Farm had a full opportunity to review that, rebut that, but they did not. They agreed to it. In its application, the about $16,000 in medical bills could not be reduced in entering judgment. The non-economic portions of the remaining verdict are not subject to reduction under this Colorado statute as well. And so that is essentially where appellant gets their stance that the judgment should be $24,295.26. To do otherwise, to enter any other kind of amount of judgment, is not to give the Colorado legislature what it intended to do. That would be the courts deciding to enter into the legislature and not follow the statutes. There are multiple Kansas cases and multiple Colorado cases, as I suspect multiple across the United States, that heavily discourage that because it affects the inherent powers that be for the executive and the legislative and the judicial branch. So going back to the second prong of this analysis, the tender in this case is not disputed. It is the specific amount of money paid of the $1,000 that was offered. And whenever you compare apples to apples, the judgment that shall be entered pursuant to the Colorado law of the $24,295 versus the $1,000, it's clear that the $24,000 number is higher. The Kansas statute at issue here for attorney's fees, the KSA 4908, the sentence really at issue is the last sentence of this, where it says, provided, however, that when a tender is made by an insurance company before the commencement of the action in which judgment is rendered, and the amount recovered is not in excess of such tender, no such cost shall be allowed. So here, the judgment, as we have already discussed, is the $24,000 number, or it should be. The way that the sentence is written does not lend to any amounts of offsets by statute or set-offs, because if the Kansas legislature intended for that to be, they would have put something in there, but they did not. The language, as I read it, is that the amount recovered under the judgment, which would be the $24,000, is the triggering number. That's backed up by Kansas case law as well. There are a list of cases that appellants cited in their brief the Cohen versus Travelers Property Casual Insurance Company case, the Hamilton versus State Farm Fire and Casualty Company case, that all say that the fees shall be allowed where judgment is in excess of the pretrial offer. It truly is that simple. Judgment is the controlling factor here. State Farm has already stipulated their way out of all of these offsets that they're trying to get now. And for Kansas to set a precedent that allows a party to back out of a stipulation whenever it's advantageous to themselves, quite frankly, is dangerous, and it's terrifying, because how are we able to count on a stipulation, count on an agreement that has controlled an entire trial? We implemented the first part of the Colorado statute, or the Colorado collateral source rule, but whenever it comes to implementing the second part of that, State Farm then wants to renege on their agreements that were made in a pleading.
Counsel, but you're about ready to get into your 5 minutes rebuttal time, which you're welcome to do. But I did wonder whether, did the Colorado court ever enter any judgment in this case?
No, Judge. There was never a Colorado court that intervened in this case. There was a private settlement reached for the underlying tortfeasor settlement, and then the UIM case was filed here in Kansas.
Okay, thank you. Okay, we'll move then to Appley's argument.
May it please the court, and thank you, Your Honors. It's interesting that the plaintiffs has taken the position that the State Farm policy doesn't apply in this case, because if the State Farm policy doesn't apply, then the plaintiffs have no cause of action to begin with. This is a breach of contract action under the policy for UIM benefits pursuant to 40-284. So if the policy doesn't apply, then there is no cause of action. So I think we have to set that aside, at least initially, in that argument simply does not hold water or flow. And then as we move next to how the policy applies, it's interesting that counsel left out an important word when he recited the stipulation between the parties. I chuckle a little bit because it's the same word that was left out by his co-counsel when we argued to the trial judge about this matter. He left out the word underlying with regard to the application of Colorado law, because the stipulation, part 2 at volume 1, page 32, is that the law of the state of Colorado will apply to issues concerning the underlying tort, including liability and damages. And that's important because under a UIM or underinsured motorist claim, it's two parts. One, and that's why the courts sometimes refer to it as a hybrid type claim, because there's an underlying tort claim against the tortfeasor that determines what the damages are. Then there is the actual breach of contract claim against the carrier, State Farm in this case, that determines the liability of the carrier. And so the stipulation is quite clear, and it's that Kansas law will apply to issues concerning the applicability interpretation of the insurance policy between the parties. And that's what we're arguing about now, is the application of the policy, because the policy is subject to the Kansas UIM statute. And then the second part, again, being the underlying tort. I'm looking here because as this came up and how it was addressed during the motions in limine, keeping in mind here that the appellant is trying to turn the motion in limine into more of a motion for summary judgment or a ruling on substantive law related to the rights of the parties versus a motion in limine that addresses admissibility of evidence. Because the motion that they filed, the motion in limine, related to collateral source, And it is at volume 1, page 47. It's also Appendix A of the appellant's motion. The motion, second motion in limine, is for an order in limine stating that no party or party's counsel be allowed to introduce any evidence of or in any other manner allude to the following subject matters during voir dire, opening statements, so on and so forth. So it's an evidentiary motion, and we agreed that the collateral sources of medical payments should not be alluded to during trial. We absolutely agreed to that as part of the motions in limine, and it wasn't referred to or alluded to during trial. With regard, all this kind of works together, but I would like to quote from the transcript regarding the motions in limine at volume 3, page 28 at the bottom, where co-counsel Chris Omlid was responding to a court's question, and Mr. Omlid says, "Judge, since this collision happened in Colorado, we have stipulated that the tort law of Colorado is what's applicable. Here, Kansas law still governs anything related to the contract, which would maybe be applicable after the verdict, if at all." So first we determine what the damages are, or what the jury determines the damages are, the loss, and then we determine the application of the policy. That's what we were going into this trial based on the stipulation, and then the argument at the motion in limine. I'm also at a bit of a loss as to the appellant's argument that even though the appellant recovered, or the jury awarded in the verdict, not a judgment, but in the verdict, less than what had been paid by the tortfeasor and by PIP payments by State Farm, that she is now entitled to attorney's fees under 40-908. And as we know from 40-284, the UIM statute, it is perfectly acceptable and allowed for State Farm to exclude or limit in its policy in the contract from UIM benefits amounts paid by the tortfeasor's liability carrier, the $22,500, which State Farm did in the policy, and also personal injury protection or PIP payments. That was a $5,000 amount paid by State Farm, which State Farm did. That is perfectly acceptable and allowed, and that's the application of the policy. Interestingly, in the argument on that motion at transcript volume 4, page 8, appellant's counsel noted that, and so there's a difference between what is recoverable and what the judgment shall be, and we recognize that. We aren't going to be able to collect on the full amount of the judgment because of the PIP and because of what the tortfeasor paid, but that's still part of the judgment and how Colorado case law statute requires the court to enter a judgment in the case. So at that time, at the trial level, they were arguing that even though we can't recover it, the court should still enter a judgment for that amount so we can get our attorney's fees. It neither makes common sense, it is neither fair, nor is it allowed under the statute, because 908 specifically states that when a tender is made by such insurance company before the commencement of the action in which judgment is rendered and the amount recovered is not in excess of such tender, no such cost shall be allowed. So at the trial level, counsel for appellant acknowledges that they cannot recover the amounts that were paid by the tortfeasor's carrier, nor the PIP payments paid by State Farm. And under 908, because they can't recover it, they're not allowed attorney's fees, even if you skip past all of the other inconsistencies within that argument. And then I guess I would say, I think that it really is pretty straightforward and simple, because a judgment's not a verdict's not a judgment. In this case, the jury rendered a verdict to determine the damages, but at that point, a judgment would not have been appropriate, because as noted by our Supreme Court in Plains Petroleum versus First National Bank. It's a 2002 case at 274 can 74. The court notes that because there was a set-off, the judgment not taking into account the set-off claim was inappropriate, because the final judgment under 60-254A specifies it's a judgment is a final determination of the party's rights. So the judgment in this case must take into account the set-off, and the set-off under the policy, and under 40-284 Kansas law regarding the application of the policy, which the party stipulated to, following the offset, the recovery is 0, and therefore it's a judgment in favor of the defendant. And because there's a judgment in favor of the defendant, the recovery is 0, no attorney's fees are allowed. That's all I have, Your Honors. Unless you have questions, I'm happy to address.
Argument. Appellant, you have 5 minutes for your rebuttal.
Thank you, Judge. The real issue at heart is whether the Colorado law applies at all. If it does, then this should fall in an appellant's favor, and it has to apply somewhere, because the third sentence of our motion in limine says that there are 2 sources for the collateral source rule. The first is the pre-verdict evidentiary component, and the second is the post-verdict set-off rule. We have followed the first part of that throughout the trial. That's the second part that we are now arguing about. Now State Farm wants to back out of, even though in their response they gave an unconditional agreement to it.
Counsel, let me ask you a question prompted by something that Mr. Norton said. Your case that you filed here in Kansas and that we're talking about today, is it a tort case or is it a breach of contract case?
Well, Judge, it's a hybrid of the 2 of them.
Your recovery from State Farm, let's put it that way, is that based upon a tort or is it based upon a breach of contract?
I would say that it's based upon both. The tort amount, the tort lends to the amount that we should receive, and the policy allows for the subject matter for the basis of the suit. The Colorado law says that judgment shall be applied or shall be entered after the reductions are made.
What's the whole purpose of the underinsured motorist claim? It's to allow your client to recover money that your client didn't get from another source, isn't that right?
Yes, Judge. It's
insurance source.
It is the stance I believe that Kansas takes on UIM is that it is there to make somebody whole, because the tortfeasor was not insured enough. They didn't have enough availability to make somebody whole.
So why don't you deduct the amounts of the recovery from the tortfeasor and the PIP payments, all made by State Farm? Why isn't that deducted from the $24,000 in damages that the jury found existed in this case?
And along those same lines, I mean, wouldn't this essentially, if we found in your favor, is that not essentially allowing your client a double recovery in effect?
Good questions. Judge Malone, if I could address yours first, and Judge Cobble, yours subsequently. Judge Malone, the difference in this case is we have the Colorado law at issue. This is not a typical, atypical Kansas case. If it was, I would 100% agree with you, 10 times out of 10. But in this case, the Colorado law is directly at odds with the Kansas policy. And if you apply, the determination has to be whether the Kansas policy controls or whether the Colorado law controls. The Colorado law, which State Farm agreed to, the Colorado law that is the collateral source rule for the entire case.
Are you saying that the court settlement and the PIP payments, you're categorizing those as collateral source payments? Is that correct? That's your argument?
Yeah, and I believe that kind of lends to Judge Cobble's question. And the intent of the Colorado legislature in this case was to provide for double recovery if that's what the circumstances allow. The Colorado court and I believe Walmart versus Crossgrove determined that.
What's your response to the basic question that the stipulation said Colorado law applies to the underlying tort claim, but Kansas law applies to the breach of contract claim? What's your response to that?
Sorry, Judge, I'm trying to put my eyes on the stipulation itself, just to make sure that I don't misquote it or try to cite it incorrectly from memory. The stipulation to an extent is not the controlling decision here. I don't believe the situation that we're in fits directly under one of the two stipulations that were entered into by the parties. It's about halfway in between the two stipulations, and so we have to, because there's not a stipulation, the choice of law or analysis has to come into play. And under the choice of law analysis, a collateral source rule, that is not a procedural rule at all. That's viewed as a substantive law. And because it's a substantive law, we have to look to determine what state's law controls. We look to where the harm happened. The harm happened in Colorado, which means that this two-part collateral source rule, the first part being the common law portion and the second part being the Colorado statute, that is what has to apply under these facts. Does that answer your question, Judge?
Yes.
And counsel, we have asked you some questions, but if you're out of your time, so if you'd like to take just a moment to summarize.
Yes, Judge. The important thing in this case is that the Colorado law does apply. The statute is in its application. If you follow the language of the legislature as it intended, as it should be followed, you make the reductions pursuant to the statute, which are none, and then it says the court shall enter judgment on the reduced amount. Shall is a strong word that got drilled into all of our heads in law school, and that word cannot be taken lightly. Whenever the legislature puts a law out into the world that says that something shall be done, it shall be done. The statute and the policy are at direct odds. There's one part of this policy that lens to say that if any provision of this policy is unenforceable, then that part of the policy is inapplicable, but all of the rest of it stays in place. That is the situation that we find ourselves in here. The offset portions of the policy are at direct odds with the controlling law, the stipulated to law. To allow State Farm to back out of that would be to put precedent in place to allow a party to renege on a stipulation, renege on an agreement. And the policy is still effective, it's still in place, but those portions where State Farm argues they're entitled to set-offs pursuant to the policy, those are no longer applicable because the controlling law is the Colorado statute. If you follow that, the $24,000 is higher than the $1,000. And by the plain language of 4908 and the case law that says you always look at the judgment number, that is the that is where appellant is entitled to attorney's fees.
Any other questions? Thanks to both counsel for your arguments today. We will take this case under advisement and get you a written decision when we can. Thank you.